Hello and welcome to PBCJ Presents, our weekly current affairs discussion series. It is here that we take a deep dive into matters affecting Jamaica land we love. I am Maya Chung. This week on PBCJ Presents, we continue our look at the latest developments within the Jamaican judiciary system. In its third staging of its series of Media versus Jamaica's Top Legal Minds called A Conversation with the Judiciary, the Court Administration Division CAD facilitated explanations on several areas of the legal system that members of the public have been wanting details and updates on for some time. Many changes have been wrought to the processes of dispensing justice over the past 3 years that have fundamentally changed the way that justice is served. Our look this week focuses on the juror selection process, the implementation of the JCMS, and much more. This week's episode forms the second part of a three-part series which culminates on April 21, 2023. Looking at the issue of the inadequate amount of the stipendiary allocation given to persons selected to carry out jury duty, the panel gave an update. Tricia Cameron Anglin, Director of the Court Administration Division, CAD, indicated that the system is plagued with insufficient jurors, which is a recurring scenario. Mrs. Cameron Anglin said,
"Let me address the matter of the jurors. We have had challenges in recent times and in the past with settling the juror list, being able to identify where persons are located given the challenges with addresses that are provided and the database that we use. We have reached out to our stakeholders. We are cleaning the list. The judges have also been trained and sensitized, as well as the staff, in more recent times. We have expanded the list so we can be able to reach the jurors where they are and get more persons coming in to serve."
Admitting that the stipend is really low, she suggested this will be changed within months.
As it relates to the stipend, we recognize that it is really low. And so we have made representation, and I can report that the Minister of Justice and the National Council on Justice, they have been looking carefully and keenly at the stipend provided for jurors. And very soon we will hear in Parliament, in Cabinet, a decision taken on the increase in the juror stipend.
In the meantime, questions were raised about the Judicial Case Management System, JCMS, a web-based system integrating all courts on a single platform, and the promises made to implement the JCMS in Jamaica to improve efficiencies within the national court systems. The JCMS is designed to, among other things, facilitate jury selection management, case flow management, and scheduling and transcript production. President of the Court of Appeal, Justice Patrick Brooks, spoke to the issue of the implementation of the JCMS in Jamaica, saying that there have been difficulties with the Court of Appeal as it relates to the JCMS.
The JCMS is having a little difficulty in terms of the Court of Appeal right now. The system requires us to scan into it all the documents which we currently have on file in the court. Mr. Earl will know that the Court of Appeal has in its files a huge number of paper, a huge number of documents, a lot of paper. To scan them, especially the larger files, will take over an hour, 2 hours to scan one file into the system. So that's the teething pain, that one of the teething pains that we're having. Our staff is doing that in addition to their day-to-day tasks, and so it is taking longer than we had expected. There are also some other issues which we'll address in terms of the delay. So to answer your question, is the time for the Court of Appeal to put in these documents. We're expecting that certainly by the end of July it will be finished.
We'll be right back with a conversation with the judiciary. We'll continue with Justice Brian Sykes. Stay tuned. We are back with a conversation with the judiciary with Justice Brian Sykes looking at the issue of statistics. Dr. Donato Dennis of the Court Statistics Unit and a court statistician who was part of the panel says the time for the implementation of the JCMS is open-ended. He added that alternative systems are being looked at which may be able to serve the interest of the justice system better. Looking at the Firearms Act and sentencing guidelines for white-collar crime, Chief Justice of Jamaica Brian Sykes admitted that in the area of sentencing generally, the workings of the justice system may be too light-handed and not enough of a deterrent for all types of crime, not just white-collar.
Well, let us take the Firearms Act. What you have to recognize is that legislation is the product of a policy taken by the cabinet and presented to their parliamentarians in the form of a bill. So we don't have any input in that. Where we come in is whenever someone is arrested and charged and placed before the court. Now, as to whether it is effective or ineffective, time will tell. I suspect that as the cases begin to come through the courts, we will see how it is working. But what I can say to you is that harsh penalties in and of themselves doesn't have any impact on crime. It never has. What is important is that the whole process is effective and efficient. So let us use an example in Jamaica. When we had the death penalty, mandatory death penalty for murdering. But years ago, murders were very low. Now it's over 1,000 per year. So even when we had the death penalty, it didn't deter persons from committing murder. So what you need to have is an efficient system end to end. So when you look at the whole process from arrest right through to trial and appeal, how efficient is that process? And where we tend to have significant delays, because when you look at the report from the Supreme Court, it will indicate to you that when the criminal cases now are ready for trial, they actually move on very quickly. The delay comes in the build up to the trial. And so what the data is telling us is that third-party actors are now responsible for significant delays. For example, defense counsel absent, disclosure to be made by the prosecution, various certificates to be provided. Those are the things that are hampering now the rate at which the cases can move on once they enter the court system. So if you have that improved and the time between arrest and trial is actually within our time standard of 2 years, I suspect it will have greater impact regardless of how severe the penalty may be, because if I am a criminal, for example, and I realize that these things are taking years to come on for trial, why is that a deterrent? It doesn't matter what the penalty is. The question is, will I be tried? And will I be tried in an appropriate time period? That is really the question. So penalties in and of themselves, while they need to be appropriate, but harsh penalties in and of themselves have not deterred people from committing crime. If that were the case, we wouldn't have any criminals today. Human beings have been around a long time. And in respect of the white-collar crimes, two things you have to bear in mind. One is a constitutional question. Most of those cases are tried in the parish courts. those courts are the first major trial courts. And going back to this, not to turn you into a lawyer now, but one of the famous cases in constitutional law in Jamaica, Hines and the Queen, where it spoke about the level of sentencing that a judge at the then resident magistrate, now parish courts, can impose. And they were saying that since the judges in those courts do not have the same level of protection in terms of security of tenure as a Supreme Court judge, then it would have been, that is one of the reasons that it would be inappropriate to give them very significant powers of sentencing. So translating all of that into English, what it means is that there'll always be a cap on what the judges of the parish court can impose. It's because you don't want to give them the powers now of sentencing that would take them into the realm of the Supreme Court without also giving them the same level of protection in terms of security of tenure and so on. So you're always going to have that cap that is there. Now, there's also other principles of sentencing you have to bear in mind. If the person is a first offender, then the law suggests that unless this crime is absolutely outrageous and way beyond the norm, the maximum penalty is not usually where you're going to end up. So if they have no previous conviction, most reasonable people would think that your previous blemish-free life should count for something. And the counting for something usually means that you do not get the maximum penalty. If the person pleads guilty, then you have to have a discount there as well. So where you have the maximum penalty in the parish court ranging from 3 years or 5 years, then you're going to have that question there as to the limit that you can impose there. Now, if you bring those matters into the Supreme Court, the question is now going to arise in terms of time, in terms of efficiency of those types of trials. So those are things that you have to think about. Now, that there's the option of consecutive sentencing there in the parish courts. Again, the principles of law outlined by the Court of Appeal in a number of cases would have addressed that.
Chief Justice Sykes also referenced the ISO certification of the Court Administration Division.
The Court Administration Division was made embodied in law in 2016. And if you look at the amendment in 2016, it is really designed to provide corporate services for the courts. So part of the ISO certification now is to transform, as part of that process, the way in which the Court Administration Division sees itself and how it relates to the courts. So the question of strategic planning, the question of the management of accounting records, the question of human resource management, the question of providing administrative support for the courts. That is really the core function of CAD. So where we are now is getting CAD to perform that role, the maintenance of court property, because we have what, 57 courtrooms, and the courts are one of the single largest employer of persons in the public sector. It has 1,600 employees. Most persons didn't know this. I didn't know this until recently. 1,600 employees and almost 2,000 posts. Yes? So that is what the Chief Justice is presiding over. So that is what CAD is designed to do. It also provides strategic planning services, and there was a recently employed strategic planner over there. So yes, so that is the framework within which a lot of this will be operating. We also partner with the Ministry of Justice, and this is where now I think, and this is not by way of criticism, it's just a fact. You don't have to take it from me. You can go and look at the records down at Parliament or the Ministry of Finance. every year the Ministry of Justice returns literally millions of dollars to the Ministry of Finance. I mean, that is just a matter of record. So the question is, why is that happening when the courts are in the state that they are in? That's an important question to us. So from my standpoint, the question is not so much a shortage of resources, because if you're returning millions, it means that the resources were allocated and we're not using it. So why are we not using it? So you might not get everything that you want in any 1 year, but the question is, over a period of time, have the resources been provided? And other than the things that the ministry immediately responsible for in terms of the infrastructure and so on now, I think the answer is yes. So this is why strategic planning now becomes important. This is why with the strategic plan from 2019 to 2023, this is the final year of that strategic plan. And some of the things that the president spoke about, that the chief judge of the parish court spoke about, when he spoke about differentiated case management, that came out of the strategic planning. If you look at it, it's online, you will see that was one of the major things that we were to put in place, but the pandemic came along and we had to now switching to online and trying to keep the courts open. But we are now back to that. And the whole idea is using resources effectively and efficiently. So when the president spoke about matching complexity of the case to the resource necessary, that is what you're really talking about. How are we going to spend the public's money more effectively? So that what should happen is that the less complicated cases, let us use a practical example, an unlawful wounding in the parish court. More often than not, those cases have usually a maximum of 4 witnesses: the complainant, a supporting witness, the police officer, the defendant. And the defendant may have a witness here go up to 5. The only document that is really required is a medical certificate. And where the defendant is saying, well, it's self-defense. The defendant is not really saying the person wasn't injured. The person is saying, yes, the person was injured, but I was acting in self-defense. So in a situation like that, those cases should go through faster. So you don't need to wait on the medical certificate, because nobody is disputing whether the defendant got an injury. But if you move on now to a fraud case, we're going to be having records from different financial institutions. You may have a question and answer being done with the police, and you're going to have all sorts of experts coming in now. Those cases will take longer. So part of the differentiated case management now is to allocate judicial and other resources depending on the level of complexity. So the simple cases should go through fast, and that is what has happened, in fact, in the parish courts. That is why over 80% of the criminal cases in parish courts are actually disposed of in 12 months. So we are now at the point where we are looking at reducing the time. The time standard across the judiciary generally is 24 months from point of entry to point of disposition. But we are now looking to get down to 15 months for the more complex cases in the parish courts, and to about 9 months for the less complex cases.
We'll be right back with a conversation with the judiciary. We continue with Justice O'Brien Sykes. We're back with a conversation with the judiciary with Justice O'Brien Sykes with the topic, are mandatory sentences a response to a high crime rate?
Once you have a mandatory minimum, then you have a floor below which you cannot go. And these questions have been raised in Trinidad, the Republic of Trinidad and Tobago, and I think the Court of Appeal there actually found a mandatory minimum to be unconstitutional. The argument is that it does not allow in the sentencing process the circumstances of the particular individual to be taken into account sufficiently so, because that was the problem that the Privy Council had with the death penalty. For example, so when you have a mandatory death penalty, a homicide can take place in an infinite variety of circumstances. So similar argument may arise. And so what it is saying then, and this is a question for, not just for judges, but for people generally, members of the public. So you, and many of us don't seem to appreciate how easy it is to become ensnared in the law, with criminal law. So for example, youngsters go out on a Saturday night. One has a bag, and he says to his friend, hold on to this for me. And just as you take the bag, the police arrive. Did you have the bag? Yes. You are going to be going to the court now to say to the judge, boy, I didn't really know what is inside there, you know. He just gave it to me, and probably that friend can't be found. Now, think you going before the judge, and the judge may be saying, I've heard this story so many times before. What do you think the judge is going to do? Think about it. So that may be an 18-year-old, a 19-year-old. So where we are now is with somebody who has a silencer or a magazine, potentially can end up with the same sentence as somebody with an AK-47 and an M16. It's a question for the society whether you think that that approach is proportionate, but we have to apply the law as it is until somebody makes a constitutional challenge, and then we'll see how it pans out. But those are questions not just for the judges, but for all of us. So it can be your son, it can be your nephew, it can be your neighbor, it can be any one of us. You may lend your car to your friend, and you don't know where the friend has stopped, who they have picked up, and the police search the vehicle and they find a bullet or two under the mat. And of course, you are going to be saying to the judge, I lent it to my friend, don't know where he went or she went. And the judge has heard that story 1,000 times before. Well, it's not for me, because this is what has been happening in reality. Over time, you have seen a shift of cases from jury trials to bench trials. And don't take it from me, you can go and do the research and look at the jurisdiction of the parish court, then resident magistrates court. And you will see that over time, and if you look through the law reports, you will see, whereas in the 1960s, robbery with aggravation used to be tried in the Supreme Court. Robbery with aggravation is only tried in the Supreme Court or in the gun court in the context of a gun crime. So even though the Supreme Court has jurisdiction and that jurisdiction remains, those cases don't come there anymore. Burglary doesn't hardly come to the Supreme Court unless it's in the context of a sexual offense, and more often than not, the persons are not indicted for the sexual offense. It's just part. Yes, for the burglary. It is presented as part of the aggravating circumstances of the sexual offense. So the reality is that over time, what we have seen is that more and more cases that used to be tried by judge and jury, tried by judge alone. So when you give the parish courts coordinate jurisdiction with the Supreme Court, in effect, what you did was to say to the prosecution, you choose the forum of trial, and they have chosen bench trials. That is why fraud cases hardly come to the Supreme Court. Because prior to the recent case that came down there, the last fraud trial, I think, was about 10 or 15 years ago. That dealt with largely in the parish courts because they give the prosecution the option. So I'm not saying it's a good thing or a bad thing. You look at human trafficking. Remember, human trafficking started out with judge and jury. And then they've switched it now to being a bench trial.
And that is it for this episode of PBCJ Presents. I have been your host, Maya Chung. Our topic has been a conversation with the judiciary. Follow us on YouTube, TikTok, Twitter, Facebook, Instagram, and email us your feedback at pbcjpresents@pbcjamaica.org. Stay tuned. We have more great programming coming up.